Next call is a split call. The Honourable David Parker.
And a 1 minute bell, sir?
Yes, 1 minute bell.
Thank you, Mr Speaker. I want to respond to some of the statements by earlier speakers on the part of the National Party. It is now a matter of record that John Key said on Campbell Live that no New Zealanders' email content would be looked at. He has since admitted that that is not correct in respect of the cyber security function of the GCSB. And then he's come to this Parliament today in the third reading debate and said that despite him having that wrong on Campbell Live, this interview that the media said was par excellence, he now comes to Parliament and says, well, trust me, I know what I'm doing. I'm not going to put the protection in the law, but I'm not going to give a first-round warrant in respect of Clause 8A cyber security warrants that allows the GCSB to look at the content of emails. But he will do it on second-round warrants.
Right.
But he will do it on second-round warrants.
Anyway.
And in any event, there is no protection in this legislation against the content of emails being looked at by the GCSB in respect of 8A investigations into cyber security. I would have thought that in itself would be enough for the National Party and their support parties to be saying, whoa, looks like the Prime Minister got that wrong, we shouldn't be voting for this. But no, they continue to vote for it. Next issue. The Honourable Chris Finlayson, in response to a contribution I made in respect of 8B, in Clause 8B, which is the intelligence gathering function, not the cyber security function aspect of this bill, rightly pointed out in his response in the committee stage that Clause 14 says that there is some restriction on the Bureau's function in 8B in respect of intercepting private communications. What he didn't address was the Law Society's concern that the definition of private communications is narrower than the definition of communications. And so when the Attorney General in this debate, Tony Ryle in this debate, said that concerns around metadata were irrelevant, he was bypassing the concerns raised by the Law Society that the definition of private communication, which is narrower than the definition of information infrastructure, which includes any communication, there is a difference between those two definitions, and there is an argument that has been put by some that metadata is not the sort of communication that is a private communication. And one of the amendments that the Greens put up was to try and clarify the fact that metadata was in effect private communication by removing that ambiguity that the Law Society says exists. Now, we have today seen in the Privileges Committee how that metadata can contain very private elements. We know that within a 2-week period, that metadata, which was disclosed probably wrongly by Parliamentary Services to the Henry Inquiry, showed that there were 86, well, it might have been actually accessible under the Official Information Act, but it was wrong for Parliamentary Services to handle it across. But that showed 86 emails between Andrea Vance and Peter Dunn in a period of less than 2 weeks. It's very unusual to have 86 emails like that, and there have been various innuendos that have been put around as to what it signified. I'm not perpetuating those innuendos by this contribution. I'm making the point that the privacy considerations of a quantity of emails are in that metadata. Secondly, that metadata disclosed by Parliamentary Services in the Dunn instance included reference to a meeting, which was in the subject line of the email rather than in the body of the email, and they thought that that was metadata. And arguably, if the Law Society are right, that might be the sort of communication that is not a private communication as opposed to the body of an email, and that is not clarified by this legislation. The oversight by the Intelligence and Security Committee, the Honourable Phil Goff's already spoken about that. I'll make one additional point. There is an express prohibition on that committee. The functions of that committee do not include inquiring into any matter that is operationally sensitive including any matter that relates to intelligent collection and production methods. So that's no great solace either. Mr. Speaker, this bill ought not to be supported.
I call Stephen Browning.